Good morning, ladies and gentlemen. Good morning. We have a lively group today. Good morning. My name is Peggy Tonin. I'm an attorney, and I'm a faculty member at the University of Montana School of Law. It's my pleasure today to welcome all of you to this session of the Montana Supreme Court and to introduce the case that you're going to hear today, the state of Montana versus Rusty Lee Ray Russell. I especially want to welcome those of you who've never seen the Supreme Court in action before. Raise your hand if you've never seen the Supreme Court in action. That's like all of you. Okay. For many years, the Montana Supreme Court has made it a practice to come hold formal sessions of the court outside of Helena. In fact, I think it's been more than 20 years. The court does this to help all of us better understand the judicial system and the important role of judges and lawyers in that system. You know, by being here today, you're joining a very, very, very small minority of citizens of this country who've had a chance to actually see their highest court in action. I think the Supreme Court should be commended for giving all of us this opportunity, and I applaud all of you for taking the opportunity. Now, if anything you hear today about the court system sort of piques your interest and you want to learn more about the Montana court system, more than what you'll hear today, I encourage you to tap into their website. So now I want you to hold out your palm, take a pen, and I want you to write down www.montanacourts.org if you're interested. montanacourts.org. Okay? I want to impress upon you that the role of law in every individual life, you know, it cannot be underestimated. It affects every aspect of American life. If you buy or rent a home, if you get married, if you get divorced, if you pay a traffic ticket, if you start a business, if you pay taxes, if you deal with a family member's death, if you do any number of other ordinary everyday things, you're affected by the role of law in your life. The American government is set up in such a way that the most significant political, social, and economic issues that we face will at some point be resolved in a court of law. Therefore, in order to be really full citizens, it's important to understand our legal system and to understand the role and the impact of lawyers and judges and courts in our society's past and future. Again, for that reason, I really applaud you for being here today. So I'm going to take a few minutes to do two things. First, I'm going to introduce and talk a little bit about the foundations of the court system, and then I'm going to take a little time discussing the case you're going to hear today. Montana has three major court systems: the federal courts, the state courts, and the tribal courts. And each of those systems is essentially divided into two parts: the trial courts and the appellate courts. The trial courts hear and they resolve criminal and civil matters or disputes. The appellate courts determine if any errors have been made during the trial court's resolution of those disputes. So of those three systems I mentioned, federal, state, and tribal, let's look at the federal court system briefly first. In the federal system, their trial courts are the magistrate courts and the district courts. Montana is fortunate to have three active duty federal district court judges: Chief Judge Richard Siebel in Billings, Judge Don Malloy in Missoula, and Judge Sam Haddon in Great Falls. We also have three federal magistrate judges: Jeremiah Lynch here in Missoula, Keith Strong in Great Falls, and Carolyn Ostby in Billings. That's the trial court level. Now, the federal appellate court level is comprised of the Circuit Court of Appeal and the United States Supreme Court. The federal appellate courts hear appeals from the district courts. They're divided into 13 circuit courts of appeal, and we're in the Ninth Circuit. And I think it's interesting to hear the states that make up the Ninth Circuit: California, Hawaii, Montana, Washington, Oregon, Idaho, Arizona, Nevada, Guam, and the Northern Mariana Islands. It's the largest circuit. We're also privileged to have a Ninth Circuit judge, Judge Sid Thomas, who is in Billings when he's not called away to Seattle or San Francisco or other sites to hear appeals. There are many other federal courts dealing with, you name it, immigration, bankruptcy, taxation, the military. In fact, it's been a pretty exciting week here in Montana for the law school. This is our traditional law week, and normally it culminates with hearing the Montana Supreme Court. This time we've been privileged to have two courts appear. Just this past Tuesday, the United States Court of Appeals for the Armed Forces had a session in our law school, and one of our law students was able to argue in front of that court. If you have an interest in the military court system, which is another whole system, they also have a website, which is, get out your palm, www.armfor.uscourts.gov. So that's the federal system. What about Montana? Montana, their state system, much like the federal system, has a trial level and an appellate level. The trial courts in Montana include two different types of courts. One is what is called the courts of limited jurisdiction, and by that it means there are certain limits to what they can hear, what they can do. They include the JP courts, the city courts, municipal courts. Okay, since the lights aren't too bright and I can see you, raise your hand if you've ever gotten a traffic ticket. Yeah, that's just about everybody again. Okay. If you've ever gotten a traffic ticket, then you've been involved with the courts of limited jurisdiction, okay? Because you probably appeared in front of a JP or a city court judge or a municipal court judge. In addition to those limited courts, there are the district courts. They are general jurisdiction courts. They handle more serious matters. They handle felonies. They handle more serious civil disputes. In Montana, we've got 22 we're a big state, so we have 22 judicial districts. The case that you're going to hear today arose out of the 13th Judicial District. That's the district that comprises Yellowstone County. Now, appeals from the district courts go to the Montana Supreme Court, the court that you're going to hear today. 7 justices make up that court, and including Chief Justice Carla Gray, and she will introduce the rest of the judges to you today. In addition to the federal and the state court systems, there's the tribal court system. There are currently 7 reservations and 10 tribes within the state of Montana, and the tribal courts vary in how closely they resemble the state and federal courts. Some of them are essentially mirror images, and others rely much more on traditional tribal approaches. So that's our court system in Montana in a nutshell. So I want to take a few minutes now to talk about the case that you're going to hear today. On the evening of April 25th, 2005, just about 3 years ago, the appellant, the person appealing the case, the defendant in the lower court, Rusty Lee Ray Russell, and his friend, Brandon Spotted Wolf, spent the evening getting very, very, very intoxicated. They spent a few hours at several bars. They went to a residence, and they ended up in an alley near the loading docks behind the St. Vincent de Paul thrift store in Billings, where they shared some whiskey and some vodka and some more alcohol with another man by the name of Henry Rideshorse. Now, near the St. Vincent de Paul thrift store, there were several transients, homeless men camped in the area, sleeping either near the loading docks or the dumpsters. One of the 2 men, Spotted Wolf, approached one of the sleeping men, Dale Wallen, and decided to see if he could, get some more money, get some alcohol from him. When Wallen said that he didn't have any money, the appellant in this case, Russell, pulled out a knife and gave it to Spotted Wolf, and Spotted Wolf proceeded to cut Wallen's face. Spotted Wolf, according to the testimony, gave the knife back to Russell, who then also assaulted or stabbed Wallen. The 2 men then left Wallen, and they walked further down the alley, where they found another transient, a man by the name of John Gowanski, who was sleeping next to a dumpster on a cement slab, and one or both of them began repeatedly hitting him. At trial, Spotted Wolf testified that it was Russell who did the hitting, and that he didn't get within 5 feet. But some of Gowanski's blood was found on Spotted Wolf's pants. After the assault on Mr. Gawinski, they both walked back to where Wallen was, and Russell began hitting him again. The two men eventually fled the scene. Mr. Wallen, the first man who was assaulted, was able to get to a nearby rescue mission, and he was taken by ambulance to a hospital, and he survived his cuts and stab wounds. Mr. Gawinski, the second man who was assaulted, he died from his stab wounds at the place where he'd been sleeping. Spotted Wolf entered into a plea agreement, or an agreement with the state, and pled guilty to deliberate homicide by accountability, aggravated assault, and robbery. He also testified against Russell at trial. Russell, the appellant here today, pled not guilty to an amended information, and an information is just another word for a charging document, that charged him with 4 counts: the deliberate homicide of John Gawinski under the felony murder rule, aggravated assault of Wallen, the robbery of Wallen by accountability, and the aggravated assault of Wallen by accountability for having provided Spotted Wolf the knife. Mr. Russell was found guilty by a jury of all 4 counts and was sentenced to 80 years in the Montana State Prison with 10 years suspended for the deliberate homicide. He was then also sentenced to 10 years on each of the other 3 felonies, but those 10 years were ordered to run concurrently, which means sort of on top of each other, but those 3 10-year sentences were ordered to run consecutive or after the 80 years with the 10 suspended that he got for the deliberate homicide. Mr. Russell has appealed his conviction to this court, the court you're about to see, and has raised 3 issues on appeal. The court, however, has asked the parties, the people you see seated up front here today, to only argue one of those 3 issues. The issue you're going to hear today is whether the sentence that Russell received violates the state constitutional prohibitions against double jeopardy. It is Russell's position that the sentence he received for the aggravated assaults should have been merged with the deliberate homicide, that they were the same, and that by being sentenced and charged and sentenced separately, he was subjected to double jeopardy, or being tried for the same crime twice. So what does all that mean, what I just said? I think it might help to look at 2 terms that you're going to hear quite a bit and talk about them for just a minute. 2 of those important terms are double jeopardy and the felony murder rule. Now, felony murder, what does that mean? The Montana Code Annotated, which is the name for our statutes, our legislation, includes the offense of deliberate homicide. A person commits that offense, most people call it murder, in the statute we call it deliberate homicide. A person commits that offense really in one of 2 ways. Under subsection A, you commit that offense by either purposely or knowingly causing the death of a human being. That's pretty straightforward, right? You take a gun, you shoot someone, they die. You purposely or knowingly kill somebody, okay? Or the second part is that you can be convicted or charged with deliberate homicide by committing or attempting to commit or being legally accountable for your or another's attempt or commission of a forcible felony. That's another word you're going to hear, a forcible felony, in which, as a result of that felony, somebody dies. Okay, so what does that mean really? I want to give you an example. I'm sort of taking out a Law and Order. 2 men enter a liquor store. One man's the lookout. He stays by the door. The other man goes further into the store. He's got a gun. He approaches the clerk, says, "Open the cash register." The clerk won't open it. The man shoots him, kills him. The 2 men, the lookout and the man who did the shooting, flee the scene. They can both be charged with the deliberate homicide. Okay? One, because he did the actual shooting. The other, because he's accountable. He aided and abetted in a forcible felony, in that robbery. And so he's responsible for what happens. And if somebody dies, he's responsible for that. The legislature, when they created the felony murder rule, basically said, you know, if you engage in inherently dangerous activities, Forcible felonies, things like robbery, aggravated assault, sexual intercourse without consent, forcible felonies. If you do that, then you're responsible. You're on the hook if something happens, if somebody dies, even if you don't fire the gun or you don't wield the baseball bat. Okay? So that's the theory. So how does that apply to the case you're going to hear today? Here we have two men, some witnesses, who were very, very intoxicated and probably somewhat fuzzy about what happened. But we do know that they were both involved in an aggravated assault on one man. And remember, an aggravated assault is a forcible felony. It's inherently dangerous. And they were both, one or both of them was involved in the stabbing of another. And so with the fact that Mr. Gawinski died and aggravated assaults took place, the individual's on the hook or is responsible for that death. Okay. So let's look at the second term, double jeopardy. How many of you have heard the term double jeopardy? Good bunch, okay. That term is derived from both state and federal constitutions. Article 2, Section 25 of the Montana Constitution and the Fifth Amendment to the United States Constitution protect individuals from multiple prosecutions and multiple punishments for the same offense. Again, so how does that apply to what you're going to hear today? The appellant, Mr. Russell, is taking the position that he should not have been sentenced for the aggravated assaults because they were the predicate or underlying offense as part of the felony murder, and they merged. He says that to be sentenced for both would be double jeopardy, or to be punished twice for the same act. Okay, so now you've heard those two key terms that you're bound to hear today in the argument. What are some of the additional legal arguments that you might hear today? Both the appellant, Mr. Russell, and the respondent, the state, have submitted briefs to this court outlining their positions. They both cited federal and state cases that deal with the felony murder rule and with double jeopardy considerations. They both cited a federal case, Whalen v. U.S., which is a Supreme Court case that held that when a rape formed the basis or was the underlying felony for a murder case, that the double jeopardy decisions of the United States Constitution prevented the sentencing court from imposing consecutive sentences for both the rape and the felony murder, which is the position that the appellant would like the court to take. However, both parties have also cited several key Montana cases that may or may not support their positions. You're going to hear a lot of discussion, likely, about the cases of State v. Close, State v. Weinberger, and State v. Guillaume. In the first two cases, Close and Weinberger, this Montana Supreme Court, relying on federal authority, ruled that the legislature intended separate punishments for the underlying felony and the murder, and that they didn't merge, and that they could be sentenced separately. In the third case I mentioned, in Guillaume, the court addressed not the felony murder rule, but another issue, a weapon enhancement issue, and ruled that the double jeopardy provisions of the Montana Constitution did apply and afforded greater protection than the United States Constitution. The appellant today will likely argue that the court has not yet addressed the felony murder rule issue and the merging of crimes under the Montana Constitution. It's been addressed under the federal, but not the Montana. The appellant's going to ask the court to look at the Montana Constitution and find that under what some in the court have said are our greater protections, that it would be double jeopardy to allow the merging, to not allow the merging of those two charges. As you might imagine, the respondent, the state, also has a position in this case. The state in its brief has argued essentially the same cases. It's argued that Close and Weinberger, the first two cases I mentioned, clearly state that the underlying offense and the murder do not merge and are separate, which is what the legislature intended, and have not been overturned by Guillaume, the third case. The state notes that the Guillaume decision never mentioned Close as an argument to say it didn't overturn Close. The state will argue that in the dissent to Guillaume, there was some discussion about the fact that no, our Montana Constitution doesn't provide greater protection, it's the same, it's coextensive, it's coexistent with the federal. In a moment, you're going to hear from the parties, and you stop hearing from me. But before that happens, I'd like to give you a little bit more information about the procedure you're going to see today. As I mentioned, both of the parties have filed written briefs setting forth their positions, and the judges and their law clerks have had an opportunity to read the briefs. Mr. Rusty Lee Ray Russell, the defendant at trial and the appellant here today, is represented by Coann Mercer of the Appellate Defender's Office. Mr. Mercer will present his client's case first and will set forth reasons why Mr. Russell's convictions should be vacated and he should receive a new trial, or, in the alternative, that his sentence for aggravated assault should be vacated. The state of Montana, the party who prevailed in the court below, and is represented by Montana Assistant Attorney General Mr. John Paulson, will respond to the arguments made by the appellant. The counsel for the appellant will then have the last opportunity to address the court to rebut any arguments raised. Now, in oral argument, the justices, and you'll see this happen, and it's sort of fun. I think it's probably the most fun part watching this. They're going to interrupt these attorneys who are arguing. They're going to interrupt in the middle of a sentence, and they're going to ask a question, and they're going to want to know some answers. And if you're an attorney up here arguing before a court, you want that to happen. Because if the judges said absolutely nothing, if it were me, I'd be really worried that, they've already made up their mind, or they don't like my argument, or whatever. You want them to ask you questions. And so that's, I'm sure, what you're going to see today. You're going to see the justices sort of pepper these attorneys with questions. Now, according to the rules of appellate procedure, the appellant is going to have 40 minutes to present his argument, and the respondent will have 30 minutes. And as I said, the appellant can break that up into two pieces. They're not obligated to use all their time, and the court can terminate the argument or give them a little more time if they see fit. So what happens after we're all done here today and the judges take the case under advisement? They're going to go back to Helena, they're going to meet in conference, and they're going to discuss the case. And one justice will be assigned to write the written decision. Then the draft of that decision will be circulated to all the members of the court, and they'll have a chance to suggest changes. Sometimes judges will write what's called concurring or dissenting opinions. They may agree with what the majority opinion says, but in a slightly different way. Or they may disagree with it and write a dissenting opinion. The final decision of the majority and any of those concurring or dissenting opinions will then be filed with the clerk of the court, Mr. Ed Smith, and it will ultimately be printed as part of the official set of court rules known as the Montana Reports. I want to give you just a brief word about courtroom etiquette right now. In just a few minutes, this theater will no longer be the University Theater. It will be the Montana Supreme Court. So after this introduction, the clerk of the court will announce the opening of the court, and he'll direct all of us to stand. The justices will enter, and they'll take their seats, and then we'll be directed to be seated by the Chief Justice. The court will then be in session, and the arguments will begin. If you're wearing a hat, it's customary to show respect for the court by removing your hat, so I'd ask you to do that, please. And if you have a cell phone or a beeper, turn it off now. Thank you. I'd like to again welcome all of you. I have to say, I don't think we've ever seen the theater this full for a Supreme Court argument, and that is fantastic. And it's a great privilege for us to be here and for all of us to see this court, and I thank you for being here. So, in just a few minutes, they're going to turn this podium around, and you will hear the case of the state of Montana versus Rusty Lee Ray Russell.
The lawyers perhaps don't want to turn around and realize how many people are here this morning. Good morning. Welcome to the Montana Supreme Court's annual spring oral argument here in the beautiful garden city of Missoula on the campus of the illustrious University of Montana, hosted by one of the finest schools of law in the country. The court looks forward to this event very much every year. It's a highlight on our yearly calendar. We get to get out of our offices, be around lots of real people, have fascinating conversations, and not incidentally hear usually very top-notch oral arguments in a case. We all appreciate that you all have taken time out from your very busy day to be with us here this morning. This is an interesting case. We take these cases on the road, so to speak, a couple of times a year to have the public have an opportunity to see their highest state court in the way we hear oral arguments in cases, which, as you already understand, is totally unlike trial courts with juries and lawyers being excited and jumping up and making objections and all that sort of thing. But we're delighted to be here as always. Before we get started, Mr. Smith, our clerk of the Supreme Court, has introduced himself, but I'm not sure you could hear him. He's with us this morning. I'd like to introduce the members of the court, starting from your right, Justice Jim Rice, then Justice Brian Morris. I'm Chief Justice Carla Gray. To my right is Justice John Warner, then Justice Bill Leaphart, and Justice Patricia Cotter. Justice Jim Nelson is, of course, also a member of our court. He is unable to be with us here this morning, sends his sincere, and they really are sincere, regrets at missing the event. He will participate in the case after listening to the oral argument tapes. And with that, this is the time and place set for oral argument in this court's cause number DA 060767, the state of Montana versus Rusty Lee Ray Russell. Our counsel ready? You may proceed.
Chief Justice, Justices, Counsel for the State, may it please the Court. My name is Cohen Mercer. I represent the appellant, Rusty Russell. In State v. Close, this Court recognized that federal double jeopardy law does not prohibit the legislature from imposing multiple punishments on a felony murder and the underlying felony. Later in State v. Zabawa, this Court similarly recognized that federal double jeopardy does not prohibit multiple punishments for a weapons enhancement and the underlying weapon that had the use of a weapon as an element. Both of these decisions rested exclusively on federal double jeopardy law. Several years later in State v. Guillaume, this Court addressed the weapons enhancement issue in Zabawa under the Montana Constitution. And in Guillaume, this Court held that the Montana double jeopardy clause does prohibit the imposition of multiple punishments for the same offense, regardless of legislative intent. Guillaume did not overrule Zabawa, rather the two cases looked at distinct issues of federal and state law. This Court said in its decision in Guillaume, said of its decision in Zabawa, Zabawa is, quote, distinguishable from and has no bearing on the instant case. The situation is exactly the same here. Close, like Zabawa, is a federal law case. As Zabawa was distinguishable from Guillaume, so the federal argument in Close is distinguishable from the state law argument here today.
Counsel, before you continue with your legal argument, I was a bit confused about the 4 counts, and in discussing it with the court this morning, we were all a bit unsure. Count 1 is the felony murder count.
That's my understanding.
Count 2 is the aggravated assault, which is the underlying predicate offense for the felony murder?
Yes, Your Honor, although it would also appear that the accountability served as a predicate offense. They were both listed in the jury instruction and in the jury's verdict.
But my question is, count 2, the aggravated assault, appears from the briefs to be concern the aggravated assault of
It's Mr. Wallen, Your Honor.
Wallen, and yet the felony murder is the murder of Gawanski. Is that correct?
That is correct, Your Honor.
So the predicate offense for the felony murder is the assault of a different individual than the person who was actually murdered.
Correct, Your Honor.
Thank you.
We're not asking this court to overrule Close. We're asking this court to apply the controlling state law precedent, which is Guillaume. In Guillaume, this court held, quote, "The double jeopardy clause of Article 2, Section 25 of the Montana Constitution prohibits the legislature from imposing multiple punishments for the same offense. Montana's double jeopardy clause is binding on all branches of government and prohibits the legislature from imposing multiple punishments on the same offense, regardless of legislative intent. What then is same offense for these double jeopardy purposes? Guillaume and its progeny hold at a minimum that the same offense is where one offense is included within the elements of the other offense. Under Guillaume's double jeopardy analysis, Montana's double jeopardy clause prohibits multiple punishments where one offense is included within the elements of a second offense. Montana statutory law confirms the same limitation. Taken together, 4611.410 and 461202 prohibit the imposition of multiple convictions for included offenses. The state has suggested in its response brief that this court has backed away from Guillaume. I would suggest that that's not an accurate reading of the Guillaume progeny. In the approximately 30 published decisions from this court citing Guillaume, not once has this court questioned Guillaume's core holding that Montana's double jeopardy clause imposes a limit on the legislation with respect to multiple punishments for an included offense. In cases such as State v. Becker, although not directly citing Guillaume, this court has gone so far as to suggest that it would be ineffective assistance of counsel to rely merely on the federal double jeopardy claim and not to recognize the unique protections of Montana's Constitution and statutory double jeopardy. Just this week in State v. Condo, this court again affirmatively cited Guillaume for the proposition that Montana's double jeopardy clause provides greater protection against multiple punishments than the federal double jeopardy clause. In each of the Guillaume progeny cases cited by the court, or by the state, this court has faithfully applied the Guillaume double jeopardy analysis. These holdings are completely consistent with our argument here today, and none of these cases even hint that Montana's double jeopardy clause allows multiple punishments for an included offense, and yet such multiple punishments are exactly what the state is seeking in this case. In this case, the aggravated assault was an included offense of the felony murder. Mr. Russell's jury was expressly instructed that the definition of felony murder in his case included commission of an aggravated assault. In the jury's felony murder verdict, the jury expressly found that aggravated assault was a necessary element and had happened. An offense doesn't get much more included than that. The aggravated assault was an express, necessary, found by the jury, definitional element of the felony murder in this case.
But counsel, are the elements the same if the aggravated assault of one person is the predicate for the felony murder of a second person?
Yes, Your Honor. I hesitate because of an issue that is not before the court today. I'm personally not sure there is a felony murder in this case. However, I believe the elements are the same. It is that you have to have committed or been accountable for an aggravated assault.
And even if there are two different people involved or two different victims involved?
So long as it is in the course of the commission of the aggravated assault.
And counsel, is it true that your argument would extend far beyond this case, and any predicate offense to a felony murder henceforth, if the court agrees with you, could not punish both the predicate offense and the felony murder?
If it is the specific predicate offense that was used to define the felony murder in that case. So for example, in this case, it's worth noting that there is a robbery conviction, and that robbery is among the potential forcible felonies that can support a felony murder. But we're not claiming that robbery was an included offense of this felony murder, or that there's any double jeopardy problem between the robbery and the felony murder. But where the felony murder is defined expressly based on aggravated assault, then that aggravated assault is an included offense of the felony murder.
Accepting your argument, had the discretion of the county attorney been moved to charge the robbery as the predicate offense, your argument could just as easily shift to the robbery. Is that correct?
The robbery would then be, multiple punishments for the robbery would be prohibited, but then multiple punishments for the aggravated assault would be allowed because it was no longer the predicate felony.
All right.
Counsel, you said in a comment there that you weren't even sure, actually, in your personal opinion, that a felony murder had occurred in this case. I'm game this morning. Why don't you tell us why you don't think that to be the case?
I think the assaults on Mr. Wallen were completed, and that therefore the assaults on the second individual who was asleep down the alley in a different place were not in the course of those assaults.
So on the basis of the facts, the time frame involved in the commission of the offenses?
That would be my position were I allowed to argue it. Again, the court has addressed this and said that I'm prohibited from arguing that.
Thank you.
Again, an included elements test, as in Guillaume, does not look at the individual factual overlap of the charges. It looks at the elements of the offense, but it looks at the particular elements that were used. So for example, in Guillaume, what was at issue there was a felony assault. And at the time, felony assault could be committed in a number of different ways, not all of which required use of a weapon. But because Guillaume's particular felony assault was defined with the use of a weapon as an element, then the weapons enhancement was an included offense of his felony assault. In a similar case, State v. Smith, another Guillaume progeny, this court held that a weapons enhancement was an included offense of assault on an officer. Although not all assaults on an officer required the use of a weapon, the assault on an officer in that case was defined with the use of a weapon as an element, so the weapons enhancement was an included offense of that assault on an officer. Same with felony murder here. The aggravated assault is how the felony murder in this case is defined. It is a necessary element of the felony murder in this case, therefore it's an included offense, therefore multiple punishments are prohibited. The United States Supreme Court has recognized the logic of this in both Harris v. Oklahoma and Whalen v. United States. In those cases, the United States Supreme Court held that the predicate felony in a felony murder is an included offense of that felony murder. In Whalen, the government actually argued that because felony murder can be committed based on a number of different forcible felonies, that no particular forcible felony is ever a necessary element. This court in Close, in the context of its legislative intent analysis, used a similar reasoning and cited to the dissent in Whalen. Ironically, the majority opinion in Whalen addresses this argument and expressly rejects it. The majority in Whalen says that the predicate offense is an included offense of the felony murder. This court has also held in the context of a felony murder that the predicate felony is an included element. That holding came in State v. Coleman. It was a 1979 case that is of particular interest today because the defendant in Coleman actually raised both federal and state double jeopardy challenges to the imposition of multiple punishments for a felony murder and an aggravated kidnapping. The defendant in Coleman was convicted of 3 offenses. First, a felony murder based on simple kidnapping. Second offense, an aggravated kidnapping. And third offense, a sexual intercourse without consent. In response to the defendant's double jeopardy claims between the aggravated kidnapping and the felony murder, this court in Coleman applied an included elements test consistent with what we're asking the court to apply today. This court, in its double jeopardy analysis in Coleman, did not mention or in any way consider legislative intent. The court simply applied a test to determine whether all the elements of one offense were included within the elements of the other.
Counsel, I want to go back to what Justice Cotter was asking about, where you have the predicate felony involving a separate victim. If we have a situation where I'm intent upon assaulting someone, say we're in a park and I'm going to attack them, in the course of attacking them, and my intent is to assault that person, someone attempts to come to their aid, and I have a knife on me, and in fending off the person giving aid, I stab them and murder them. So I assume we could have felony murder charge based upon my killing of the person trying to give help to the victim. Are you saying that the state has to choose between charging the felony murder and then charging the assault that had taken place on the initial victim?
Not at the charging level, Your Honor. I think they can charge both. They can take both to trial. They can't get multiple punishments for an included offense.
So I can't get an extra 10 years for the assault on top of the...
And Your Honor, at a policy level, if we're even talking about felony murder, we're already talking about the possibility of 100 years life in prison without the possibility of parole. But yes, you could not go beyond that under Montana double jeopardy law and impose another separate punishment for the same included offense.
Because you've already been punished?
Because
for
you've
that
already been
event.
punished. It's an included offense of the offense for which you already received the 100 years.
But counsel, usually in a double jeopardy situation, we're talking about overlapping elements of offenses. I'm struggling a bit with your concept that because felony murder necessarily involves the commission of another felony, that somehow is an element in the way we normally apply the rules relating to double jeopardy.
We believe it is an element, Your Honor. Again, that's what the United States Supreme Court has held in Wallen.
Counsel, are you wanting us to adopt under the Montana Constitution United States Supreme Law authority or Supreme Court authority at this point?
I don't cite it as binding precedent, merely that they recognize the logic that an included offense, the predicate offense in a felony murder is an included offense. Again, state or federal double jeopardy law hinges on legislative intent, and this court in Guillaume has said that Montana double jeopardy law does not. The case that I was discussing, Your Honor, Coleman, is an example, again, in which the defendant raised a double jeopardy claim between a felony murder and aggravated kidnapping. In conducting the double jeopardy analysis of that, this court expressly stated that the simple kidnapping was a necessary element of the felony murder predicated upon kidnapping. Where the defendant in Coleman lost is that because his felony murder was defined based on simple kidnapping, aggravated kidnapping, which has an extra element of intent or purpose to terrorize, was not an included offense. But that holding is completely consistent with our argument today. Again, with respect to the robbery in this case, we are only saying that Montana double jeopardy prohibits the imposition of multiple punishments for the felony murder and the express felony that is used to define the felony murder to the jury. So as in...
Go ahead. Yeah, I was going to ask in Coleman, wouldn't it depend upon which kidnapping the prosecution chose as being the predicate, whether it was the simple kidnapping or the aggravated?
Yes, Your Honor. If they had defined the offense to the jury as aggravated kidnapping, then aggravated kidnapping would have been an included offense.
Right.
The logic is...
So it doesn't matter what the elements of simple kidnapping are versus aggravated kidnapping. It depends on which one the prosecution has chosen as the predicate offense. And if they choose it, then it then becomes an element of the felony murder.
It's a little bit more complicated with respect to aggravated kidnapping, because if they had chosen aggravated kidnapping, then I don't think they could have prosecuted on simple kidnapping either, because all the elements of simple kidnapping are included in aggravated. But other than that, Your Honor's point is exactly correct.
Doesn't that then lead to a kind of daisy chain, counsel, where if you have several offenses and one of them happens to be a felony murder, logically you're going to end up with felony murder only? In other words, your logic would apply to the charges that are a part of the same transaction, and so they could not be double punishment for those either.
Your Honor, the included elements of test does not look at the particular factual overlap of the case. This court has been very clear in Keith and a number of Guillaume progeny that, in Keith, for example, a lady shot up her apartment, put a bullet into her neighbor's apartment, and was charged with criminal endangerment and a weapons enhancement. She tried to claim that because she wouldn't have been convicted of anything if she hadn't have shot a gun, that she was therefore suffering double jeopardy based on the use of a gun. This court very correctly held that, no, Guillaume looks only at the elements of the offense, not at the factual overlap. It's purposely permissible to have multiple criminal offenses arising out of the same transaction, so long as their elements are not included within each other. So here again, the robbery, which is out of the same transaction, is perfectly permissible, because the felony murder in this case was not defined using the robbery. It's only the aggravated assault that has a double jeopardy problem, because the aggravated assault was used to define felony murder to the jury. That is what they found in order to find the felony murder. So any other offenses that added on, as long as they were not used as the predicate, the singular predicate offense to the felony murder, there would be no double jeopardy problem with respect to any of them. Again, just to repeat, this court in Coleman, in carrying out its included elements test, compared felony murder to aggravated kidnapping. And in doing that, this court expressly stated that the simple kidnapping was a necessary included element of the felony murder. As with the aggravated assault here, as with the simple kidnapping in Coleman, it is a necessary element. It's an included offense of the felony murder here. Therefore, double jeopardy clause prohibits multiple punishments for that specific aggravated assault and that specific forcible felony murder.
So whatever the state chooses as the predicate offense becomes subsumed into the felony murder charge. It becomes an element of that charge.
Because that is how the offense was defined in this case. And again, if you look at some of the Guillaume progeny, the same thing is happening there. In Guillaume, it's a felony assault, but not all felony assaults at that time required use of a weapon. But that is how it was defined in that case by the jury instructions and the charging documents. So assault with a weapon use of a weapon became an element of that felony assault. Same exact thing here. When the state chooses and the judge defines the offense to the jury to include aggravated assault is included element of that felony murder.
And again, counsel, just for purposes of sentencing, you're arguing, not for purposes of charging. You're not saying that the charges are incorrect, just that the sentences were
Correct, Your Honor.
cumulative.
I think procedurally the state can bring whatever charges they have probable cause for. If he's convicted on all counts, then the ones that had double jeopardy problems would be properly, there'd be a motion to dismiss, as there was in this case. Those convictions would be dismissed and he would be sentenced on the remaining counts. But certainly you could proceed to trial with, it's a sentencing problem, not a trial problem, Your Honor. Very briefly, Your Honors, there is a second double jeopardy issue in this case.
Counsel, could I back you up just half a step to your last comment? If it's, your argument, as I understand it, is that the state had to prove the aggravated assault to the jury beyond a reasonable doubt.
Correct, Your Honor.
Is it just a sentencing problem, or is it a double conviction problem?
I misspoke, Your Honor. It is a conviction problem, not a sentencing. Indeed, if you rule for Mr. Russell's favor in this case, you will not change his sentence by a day because the robbery is consecutive. But there are U.S. Supreme Court cases that note that there are potential collateral consequences to a conviction in and of itself, and we believe, therefore, it's the conviction itself that must be vacated. I would note that Montana statutory law with respect to the same issue addresses multiple convictions, not multiple sentences. There is a second double jeopardy issue in this case. That is the double jeopardy between the aggravated assault and the accountability for aggravated assault. I think pretty clearly under Montana law, accountability does not define a separate offense from the underlying offense. Accountability is a mechanism by which the conduct of one person is attributed to a second person, and then that second person is said to have committed the elements of the underlying offense. I don't read the state's brief as contesting that point. Rather, the state appears to argue that in this case, the aggravated assault dealt with one attack, and the accountability for aggravated assault dealt with a second attack, and it's a unit of prosecution type double jeopardy. It would appear that it's the state's contention that there was one complete and separate attack when Mr. Spotted Wolf slashed Mr. Wallen, and one separate attack completed when Mr. Russell, under their facts, stabbed Mr. Wallen. It is our position that there were also two completed separate attacks, and for that reason we concede this double jeopardy issue. We would note, however, though, the finding that there were two separate distinct attacks has ramifications for the other non-double jeopardy issues in this case. Your Honor, if the court has nothing further, I reserve the balance of my time.
Seeing no further questions, thank you very much, Mr.
Thank you, Your Honor.
Mercer. Counsel?
Good morning, Chief Justice Gray and members of the court. May it please the court, my name is John Paulson. I'm Assistant Attorney General for the state of Montana. Seated with me at counsel's table are Mark Murphy and Ed Zink. Mr. Murphy is a former Assistant Attorney General and is now Chief Deputy Yellowstone County Attorney, and Mr. Zink is an experienced prosecutor in the Yellowstone County Attorney's Office. Both Mr. Murphy and Mr. Zink prosecuted this case against Rusty Lee Ray Russell. We are here asking the court to affirm the district court's ruling at issue in this case that denied Russell's post-trial double jeopardy motion. And in view of counsel's concession just a few minutes ago, I will not be making any comments regarding the second portion of this double jeopardy issue, the statutory portion concerning counts 2 and 4. I'll direct some comments to the underlying question, the central question concerning the double jeopardy implications of State versus Guillaume as applied to the facts of this case. Rusty Russell used a knife to attack two men who were sleeping in an alley in South Billings. And as the court has heard this morning, Dale Wallen, one of those men, was severely injured. And John Gawanski, the other man, died from the stab wounds inflicted by Mr. Russell. The district judge imposed separate and cumulative sentences for the aggravated assault of Dale Wallen and for the deliberate homicide, felony murder of John Gawanski. Now it's clear, as argued to the district judge at the time that this motion was considered at the beginning of the sentencing hearing, that the sentences that were imposed by the court were authorized by the respective statutes involved and also by this court's decision in State versus Close. The parties are in agreement that Close, in the absence of any other considerations, would be the controlling decision, and that the cumulative sentences that were imposed by the district judge were properly imposed. The heart of Russell's appeal, then, is his contention that the court's decision in Close has somehow been tacitly overruled, or its analysis and rationale modified by the court's decision in State versus Guillaume. And I would suggest to the court there are a couple of reasons why the court should decline this invitation to extend Guillaume into the realm of felony murder. The first, as counsel has conceded, is the most apparent reason. The Guillaume decision does not mention State versus Close, and in any context, much less overrule it expressly. And in this counsel's view, the court's subsequent decisions that have applied Guillaume have limited its application to the weapons enhancement context. The state's brief points out several cases, and they're just a few of many more, where the court has expressly and clearly limited the application of its decision in Guillaume to the situation where a weapon enhancement has been imposed in conjunction with the defendant's conviction of another offense.
Haven't we limited the weapons enhancement statute to cases which involve an underlying felony which itself requires use of a weapon?
That's correct, Your Honor.
But isn't that just another way of saying we've limited to cases where the underlying offense is thereby an included offense?
I would differ somewhat from that analysis, Your Honor, in the sense that the court has not talked in connection with Guillaume with this concept of lesser included or merger.
But isn't the analogy there? I mean, we're just saying that if the underlying offense required use of a weapon, you've already been punished for use of a weapon, and the Constitution doesn't allow you to then come in and punish you again for use of a weapon.
That's correct, Your Honor. That position which Your Honor took in your dissent in Zabawa became the majority's position in Guillaume. But in Guillaume, the court was also very clear that the weapons enhancement statute does not create a separate offense. It is not an element of a criminal offense. It is a sentencing factor that comes into play at the point when the defendant is sentenced. And this court took a look at the elements of felony assault. What was then felony assault is now called assault with a weapon, but at that point in time, felony assault was committed when a person used a weapon to create a reasonable apprehension of serious bodily injury. And the court determined that that element overlapped with the sentencing factor, the enhancement use of a weapon factor, with the common denominator being the use of a weapon. And that because of the overlap, the court found that the application of the weapon enhancement statute under those limited circumstances amounted to double punishment.
Well, why is that overlap analysis not applicable to the case we have before us today? The court has, on many occasions, taken a look at this same issue, whether or not, and I'm using merger and included offense or lesser included offense somewhat synonymously here. But the court has made it clear that in the felony murder context, the predicate or underlying felony is not merged and is not a lesser or included offense of the felony murder. This court applied that analysis in State versus Close initially. This is the Blockberger test, the well-known Blockberger elements test, which looks strictly at the elements of the statute rather than the indictment or information, rather than the evidence that's produced. But in Close, the court said that it was resolved by looking at legislative intent, did it not? It did that as well, Your Honor, but it also applied Blockberger in reaching the determination that there was no merger here. The court admittedly analyzed the case a little bit differently and looked instead to the elements generally rather than to the particular charge that was involved. And the court concluded that a person can commit felony murder without necessarily including any particular predicate felony. Yeah, it said that you could commit felony murder without committing robbery.
That's correct. That was the predicate offense in that case.
But isn't that kind of circuitous? I mean, are you then arguing that if we had a specific statute that said if in the course of committing a robbery you kill somebody, that's a felony murder, would you then have a double jeopardy problem? I mean, is there a difference between a statute that says a felony as opposed to specifying, you know, a whole list of all the felonies?
There was a difference in this court's mind back in 1981 when it decided Close.
Well, but I'm asking, is that a valid distinction?
I think so. I think that distinction is valid today. It is a classic application of Blockberger, and I think underlying it is an important distinction that this court has implicitly made in subsequent decisions, and that is this: that felony murder occupies a kind of unique corner of criminal law, and it's different in many respects to the considerations, analytical considerations that go into ordinary deliberate homicide or any other offense. And the merger component or included offense component of the analysis doesn't fit very closely to the felony murder concept.
Well, let's look at the Blockberger analysis in today's case. The predicate offense is aggravated assault.
As charged, yes. That's
So
right.
in order to achieve a conviction for felony murder, the state had to prove aggravated assault.
That's correct. The state had to offer evidence to support its charge that
Okay, now-
Russell committed the aggravated assault of Dale Wallen, and during the commission or flight therefrom, he caused the death or somebody accountable
And then
for
under
caused the death of
Blockberger
Mr.
analysis, you have to have a situation where each offense requires proof of an element that the other one doesn't. So in this case, having proven all the elements of aggravated assault in order to convict of felony murder, what elements of aggravated assault are left that are different from the felony murder? Hasn't it been totally subsumed?
The evidence would be the same, Your Honor. I think there's no question about that. The state is required to show the commission or the attempt to commit the underlying felony, whether it's aggravated assault or some other of the forcible felonies enumerated in the statute. But the question of whether it's merged or subsumed is a different question altogether. I would call the court's attention to a number of its decisions that admittedly are not in the briefing, but they go to this issue. The court, after it decided close, decided the case of State versus Burns kills on top, and essentially applied the Blockberger analysis to a felony homicide, felony murder case to determine that there was no merger. More expressly, in State versus Turner, and a cite for that, 265 Montana 337, the court concluded in that case that the underlying felony in a deliberate homicide, felony murder, is not a lesser included offense, does not merge with the felony murder, but it's a distinct offense, and it permits courts to sustain separate and distinct convictions on that underlying felony and sentence the defendant for that felony as well. Turner was a prison riot case from back in 1991 where the felony murders were committed in the course of a burglary. And it's interesting in that case that the court held that it's not even necessary for the jury to return a verdict on the underlying felony in order to sustain the conviction for felony murder. They are separate offenses, and they may be punished separately.
But how does that work? If there's no conviction of the underlying felony, how can there be a resulting conviction for felony murder predicated upon the crime for which there was no conviction?
It raises a question regarding the possibility of inconsistent verdicts, which, of course, this court has held on numerous occasions are not required in criminal cases. The focus is on whether or not the evidence is sufficient to sustain the particular conviction at issue. And I believe the court's analysis was this, that the jury was entitled to, in Turner's case, they didn't acquit, they just didn't reach a verdict on the burglary charge. But
Counsel,
even
would it
in...
be possible in your argument then to charge in a single count in an information felony murder? In other words, we charge the murder of the felony deliberate homicide of Mr. X, period. And then the affidavit in support thereof lists the underlying, let's just say it's a bank robbery. And during the course of the bank robbery, the teller died. Therefore, we're only charging the death of the teller. Would that be possible in your analysis? Not to charge the robbery at all, No charge, just charge the murder
As a felony murder.
as a felony murder under that subsection.
Yes, I see no reason why the state would necessarily have to charge separately the predicate felony. I don't think that's required under the felony murder statute, but expressly it's not required, and I don't think this court's decisions have suggested
However,
that
the
it
state would have to prove that it was during the course of a robbery, correct?
That's correct.
And
That's,
therefore prove all of the elements of robbery in order to get to the murder.
that's right. There would have to be sufficient evidence in this court's view on review to support a conviction for that underlying felony, that predicate felony.
Counsel, the appellant has urged us to follow the lead of the Wyoming Supreme Court in Cook and join the majority of jurisdictions in adopting the rule that they're proposing. Why should we not do that?
There are a couple of responses to that question, Justice Morris. One is that Cook was decided with the express understanding and the citation to this court's decision in State versus Close. And it arrived at a different result, but it acknowledged that a number of jurisdictions addressed the merger question differently than the route that the Wyoming Supreme Court undertook in Cook. It was a divided decision, 3-2, and two of the justices would have upheld an earlier decision which affirmed that the predicate felony and the felony murder were not merged under Wyoming law at that point in time.
So we shouldn't follow Cook because we have Close.
I think that's,
And then the question
Yes.
arises, what effect does Guillaume have? And is it limited, as you argue, to weapons enhancement cases?
let me just
Okay, finish up your close.
point out to the court the fact that the survey that is included in the concurring opinion in Cook is not the last word on the assessment of whether or not this court would be joining the majority of other jurisdictions. This court has often looked to the Alaska Supreme Court, for example, for guidance in.
I don't want to get hung up on that. I guess you would admit that there's some difference of authority among the states, whether it's majority view, plurality.
Yes, I think that's,
Okay.
it's split, and Professor Lefebvre in his treatise acknowledges that it's a split authority, and there are a lot of jurisdictions like Montana that treat the merger issue the same way
We
as
have
Close.
split authority, and you're urging us to stick with Close. So the question is, what about Guillaume, and is it really limited? Has it changed this issue, and if so, only with respect to weapons enhancement, or has it had a broader application in all double jeopardy claims?
My reading of this court's precedent following Guillaume is this, that the case is limited to the weapon enhancement situation and doesn't apply by extension into other situations. Now, admittedly, the court has not confronted this precise issue. Now, this is an issue of first impression, at least with respect to Guillaume, but the court's not writing on a blank slate here. The court has very clearly indicated since Guillaume that these offenses do not merge in a felony murder context. This court's decision in State versus Burkhart is another example where the defendant there was, and this is a 2004 decision, five years after Guillaume came down. The defendant there was charged with the aggravated assault of the victim and the felony homicide under the felony murder rule of the same victim. He took a hammer, threatened the victim, and then chased the victim, and eventually struck the victim with a hammer. And felony murder was the theory utilized by the prosecution to prosecute that case. And this court found no merger between the underlying assault and the predicate felony, the felony, rather, that constituted the deliberate homicide, felony murder.
Was merger and under the Guillaume case argued in Burkhardt?
It's not referred to in the court's opinion. There is a lengthy discussion about it. In the majority opinion, it is not. It is in your dissenting opinion in that case, Your Honor. Your Honor discussed the question of merger and took a view which was different than the view adopted by the majority in that case.
Counsel, isn't part of the importance of Guillaume here, though, the fact that in Guillaume we said we would be looking to the Montana Constitution instead of the federal Constitution upon which our previous decisions were based? And didn't we also say in Guillaume that we will not focus on statutory or legislative intent in deciding what the Article 2, Section 25 protects? Isn't that also the important part of Guillaume here?
Yes, I don't think the court meant to say, and again, I'm making my interpretation of the court's opinion here, but I don't think the court meant to say that legislative intent is irrelevant or beyond the analysis that's required under Guillaume. Just that the Montana Constitution does have something to say in the area of multiple punishments. That's the distinction that the court made that distinguishes it from the United States Supreme Court's approach to the multiple punishment component of the double jeopardy protection. But again, I think that there is an important distinction to be made between Guillaume and Close that can be understood to some extent by a review of this issue of legislative intent. The legislature works, of course, I shouldn't say hand in hand, but certainly in conjunction with the co-equal branch of government, which is this court. And what this court does will impact what the legislature does. The legislature quite often responds to this court's decisions. And that's what happened in the case of Guillaume, as this court, I'm sure, is aware. The legislature, in the same session following Guillaume, immediately amended Montana law to increase the punishment that was available for what they now called aggravated or assault with a weapon from 10 years to 20 years, giving in effect the district judge the discretion to impose up to 20 years for the offense which before was punished by a maximum of 10 years plus 10 years under the weapon enhancement statute. So the legislature had something to say about the court's decision in Guillaume.
Nicely
With
put.
respect to Close, it's another matter. That was 27 years ago. 13 legislative sessions have gone by, and the legislature appears to be very happy with this court's decision in Close. There's been no effort to suggest that the legislature was wrong, rather that this court was wrong in its interpretation of the felony murder statute as the court constructed it in Close.
The legislature doesn't have the prerogative of saying this court is wrong, does it?
The legislature has the prerogative of either responding to this court's decision or remaining silent, which it has, and this court has acknowledged.
They can change the law, but they don't get to.
That's right.
They were wrong.
The legislature can't tell this court, as Your Honor has very aptly put, can't tell this court how to fill the contours of the double jeopardy provision. That's the function of this court.
Counsel, since we've gotten into this, would you please describe as a representative of the citizens of Montana, what is the interest of the people in resisting this case if available for felony murder is death, 100 years, or life without parole in prison? What is the interest of the people in convicting of an underlying felony such as aggravated assault? Why do they want to do this? And that of course, goes into the legislative intent also, but describe for me, what is that interest? What are they going to do to this guy after he's been imprisoned or put to death?
That was one of the arguments raised in the Cook versus Wyoming case, and it was addressed in that case. In Wyoming, the state has a statute that provides for death or life without parole automatically, I think, and so the discretion isn't accorded, or at least not quite as much discretion, I guess, is not accorded to the sentencing judges. The state's interest is making sure that in appropriate cases, the district judge can impose sentences for separate offenses and has a sentencing range that's available to reflect, in the judge's view, what sentence is appropriate for the defendant's conduct. Many homicides, certainly under the deliberate homicide felony murder rule, probably don't merit the extreme sanction of life without parole, or certainly a death penalty. It may merit something less. But in this manner, the court has a prerogative to hold a defendant accountable not only for the murder, but also for the conduct which the defendant committed with respect to the underlying and predicate felony. I think it's important for courts to be able to say, you committed a robbery and you're responsible for this murder. You committed 2 crimes. You have to be held accountable for both crimes and should pay the price. It's in effect what the court said in State versus Burkhardt. These are separate offenses. Defendants need to be accountable for both of them. And in this particular case, as the court has already recognized in its sentences and in its questioning, there were 2 victims. And why should Rusty Russell be relieved of any responsibility or accountability in terms of punishment for the assault of Dale Wallen, simply because in the course of committing that assault, he also kills John Gawlansky?
But counsel, doesn't the felony murder rule in turn relieve the state of the duty to prove intent with respect to the deliberate homicide? It allows him to basically get off with a recklessness standard with respect to the murder.
It doesn't even require a reckless standard, Your Honor.
Well, recklessness in the sense that you intentionally engaged in felony conduct in the assault and happened to murder someone, and we don't require the state to prove that was an intentional murder. Just that the intent was to engage in the initial underlying assault.
That's correct. That's the effect of the felony murder.
So given that trade-off, is there really a relieving Russell here of the responsibility for the assault on that victim?
I believe that it's quite appropriate for the legislature to decide that these are separate offenses and deserve separate punishments. The transferred intent that occurs in...
But my question, is there a trade-off, though? You talked about we shouldn't let Russell off for responsibility for the underlying assault. Well, in essence, have we really let him off if we say that we're going to use that assault to help prove the deliberate homicide?
we use the assault and prove
That's
the
an element of the deliberate homicide.
Yes,
That's
correct.
That's all you have to show. Not that I intentionally, knowingly killed this person, and just the fact that I killed him in the course of committing an assault on someone else.
I guess in that view, Your Honor, there is a kind of a trade-off that occurs. Felony murder exists because of the legislature's recognition that certain conduct carries a high homicidal risk, and that by proving the purposeful or knowledgeable commission of the underlying felony, that mental state transfers or carries over to the homicide. And as has been discussed already, even in situations where the defendant is not the trigger man or did not directly cause the death of the decedent. I don't think that trade-off should be viewed as any kind of trade-off with respect to either the charging or sentencing authority of the district court in the district court proceedings. But I understand the court's point, and I guess I can only say that the legislature has allowed this kind of charging and sentencing to occur. This court has confirmed it in numerous cases, albeit primarily using a Blockberger analysis under federal law. And I don't think Guillaume changes that analysis and should not change the result here. Just by way of conclusion, I'll again encourage the court to affirm the sentences that were imposed on Mr. Russell. Guillaume simply did not overrule the close decision and the separate and cumulative sentences, consecutive sentences for the aggravated assault of Dale Wallen and the homicide of John Gawonski don't violate the state constitutional prohibition against double jeopardy. And we ask the court to affirm those sentences. Unless the court has further questions, I will conclude.
Thank you very much, Mr. Paulson.
Thank you, Your Honor.
Mr. Mercer?
Thank you, Your Honor. If this court strikes the multiple convictions, Mr. Russell will not be let off for his conduct in the aggravated assault. The only thing that makes the death of Mr. Gawonski a crime with respect to Mr. Russell is the commission of that aggravated assault. The state chose to not charge any direct offenses against Mr. Gawonski. It is that very aggravated assault that he is being punished for in the felony murder. And that's the double jeopardy claim we're making. State v. Close, let me be very clear, was correct with respect to federal law. It is probably correct with respect to legislative intent. But legislative intent is completely irrelevant here. That's what Guillaume says, very loudly. This court in Guillaume said, quote, "The double jeopardy clause of Article 2, Section 25 of the Montana Constitution prohibits the legislature from imposing on criminal defendants multiple punishments for the same offense." The state cannot point to, and there is nothing in the double jeopardy analysis in Guillaume that in any way hinges upon one of the included offenses being a sentencing enhancement. The logic is the same regardless. It's an included offense.
Wasn't the court's Blockberger analysis in Close incorrect?
Two things, Your Honor. Because it was Blockberger is a legislative analysis test, and to that degree I think it's distinguishable and not binding. The Blockberger analysis in Close has a single cite in that single paragraph to the dissenting opinion in Whalen. The majority opinion in Whalen is directly contrary. I do think this court's decision in Close to that specific Blockberger analysis, to the degree Blockberger stands for an included offense test, was incorrect. I think it's contrary to Coleman. I think it's contrary to all this court's Guillaume's laws. It's contrary to what the United States Supreme Court said in the very case cited in Close. Also in Close, this court had just said in the preceding paragraph, which is accurate, that Blockberger is not determinative under federal double jeopardy law. You can have a thing that is an included offense, but under federal jeopardy law, if the legislative intent is clear, there's no problem with multiple punishments.
But even assuming that Blockberger is determinative, the court in Close seemed to hang its hat on the fact that the felony murder statute in Montana doesn't specifically reference robbery. It references a felony. And I just don't see that as being a valid distinction.
I, to Your Honor, do not see that paragraph being particularly well thought out, and I don't think it fits with even its own citation. Just to talk briefly about kills on top, again, the citation in kills on top is just a Close. It's the same federal law argument. It's not the state law argument. Turner is a little bit more interesting. In Turner, what happened is that the state brought a direct burglary charge, and a felony murder predicated upon either accountability for burglary or direct burglary. The jury hung or did not return a verdict on the direct burglary, but the jury found that he was accountable for burglary and that was the included element that supported the felony murder. So it was not a case in which there was no finding of the underlying felony. The underlying felony was just different than the one that was charged in the direct burglary. And I completely agree with Justice Warner that you could just bring a felony murder. There's no requirement at all that you bring the charge of the underlying felony, but you have to prove it. So perhaps to beat a dead horse, Close is a federal law case. Zabawa was a federal law case. Guillaume did not overrule Zabawa. It's a separate state law issue. We're not asking this court to overrule Close, although I think Close's Blockberger analysis was error, but it's a completely distinguishable case because it was a federal law case. Guillaume is controlling. It's the controlling state law precedent here. Nothing in the Guillaume analysis depended upon it being a sentencing enhancement. Although this court has suggested in cases such as Whitehorn that this court has not expanded Guillaume beyond its self-defined scope. When this court said that, the court was responding to a specific set of arguments. Following Guillaume, a number of defendants brought claims that tried to extend Guillaume to situations in which the use of a weapon was not an element of the underlying offense. Keith is an example, Danette, there were a bunch of them. So when in Whitehorn this court says we didn't expand Guillaume, its next four cites are to examples of those sort of factual overlap cases that very clearly Guillaume does not cover, because Guillaume looks at elements. And here, aggravated assault was an express, defined to the jury, found by the jury, absolutely necessary definitional element of the felony murder. Therefore, the aggravated assault is an included offense of this felony murder, and the multiple punishments are prohibited. Your Honor, if there's nothing further, Mr. Russell and myself will thank the court for its time and consideration.
It appears there are no further questions, but the court's thanks again to all of you who are with us this morning and to the lawyers who argued this case. We will take our class number 060767 under